The law is for everyone to follow, and no one is exempted from it, not even lawyers. No matter how intelligent they think they are, karma always gets them. Can attorneys get away with anything? Can they sway a ruling in favor of their clients or even themselves? Watch the video to see how these attorneys get owned by cops for breaking the law.
Las Vegas attorney in some trouble for a series of alleged late-night rendezvous with one of her clients.
Hal Uhrig, an area criminal defense attorney from Orlando, made headlines all over the country. Hal Uhrig, who represented George Zimmerman in the Trayvon Martin shooting incident, was arrested on various charges, which included soliciting perjury and tampering with a witness or victim. Marcos Lopez, Osceola County Sheriff, said that Uhrig took on a case involving a man named Krishnath Prasad, who had been charged of raping a 9-year-old girl. Uhrig was accused of holding a meeting with his client, the victim, and her father. Uhrig tried to cut a deal to keep the suspect from going to jail. During their meeting, Uhrig instructed the victim and her father to do 3 things. Firstly, to write a declination, that is a letter to the state attorney saying that the rape never happened.
Basically a letter to the state attorney saying the rape didn't happen.
Secondly, to avoid being served a subpoena so that they didn't have to go to court to testify, and lastly, to lie during their deposition and say that the rape didn't happen. According to Lopez, he wanted to make sure this guy didn't go to trial for rape. He added that Mr. Prasad committed the sexual battery at a time when she was 9 years old, and this is what caused Mr. Uhrig to work a deal out with the victim to try and get Mr. Prasad off on a lesser charge so that sexual assault battery cases will go to trial, and this will be a separate trial against the attorney. Even after being pressured to such an extent, the victim decided to come forward and report the conduct to the state attorney's office in July of 2021. Osceola County started an investigation against Prasad's attorney on the basis of the victim's complaint. The victim's father engaged in a controlled phone call with Uhrig and said that he couldn't talk on the phone about any specifics and wanted to meet in person. According to the officials, the father wore a recording device during his meeting with Uhrig, and during the meeting, the attorney made him turn off his cell phone and told the father to read a script off of his computer screen.
He wore a recording device, the victim's father. During the meeting, the attorney made him turn off his cell phone.
Lopez said that the script was his defense for when he goes to court on the charges. However, fate had other plans for them. Prasad, who was arrested back in 2019, is working his way through the court system. On the other hand, Uhrig is accused of soliciting to commit perjury, which is a 3rd-degree felony, and also for tampering with and harassing a victim, which amounts to a capital life felony. Given Uhrig's 40-year-long career, this might not be the first time he has done something like this. According to Lopez, if you're an attorney, you've been practicing law for a long time, and there's no way you're going to jeopardize your career on something like this, especially at that age. Especially at that age, it's retirement time. So I think this wasn't his first rodeo. Unless someone else comes forward, we won't know that, but that's what I suspect this time. The next attorney in line is Alexis Plunkett. This topsy-turvy case involves a 38-year-old attorney from Las Vegas named Alexis Plunkett, was indicted with 2 counts of conspiracy to unlawfully possess a portable communication device and 12 counts of a portable telecommunication device by a prison. The charges relate to her visit with her 28-year-old client and boyfriend at the time named Andrew Arevalo. This man was shot in the face by a high state correction officer in 2014. He also faced felony and weapon charges and was awaiting trial. His case was represented by Plunkett in his lawsuit against the Nevada Department of Corrections in connection with the shooting, which resulted in another man's death. During her visit, security camera footage shows Plunkett handing over her phone to Arevalo. Now, this is a felony that could land her in jail for a year. However, her case took a complicated turn. Even though the couple started off as boyfriend and girlfriend, they were experiencing rifts in their relationship after her phone was examined by the police. It seems that she is trying to put a hit on Arevalo. Her text messages about her joking about felonies led her to her downfall. Some of the texts read, "I've placed hits in every Nevada prison on Andrew with every homie and lifer I know." She further added, "This pause will never survive in prison now. He's F with the wrong bit. I am not the one. I represent all the sure-knows and he's gonna get it." However, one of the people in the group asked her to delete the message. He said, "Alexis, this isn't funny. I know you are under a tremendous amount of stress, but I'm not interested in joking about felonies. I don't think anyone is either.
She replied, "I am not joking. That's why I said to delete it. He said he was going to have me murdered, so I'll take care of business first."
Plunkett's attorney Adam Solinger said that her messages show that she was under great stress and she was only venting about the bad situation she was in, and that her words shouldn't be taken as a serious threat. Despite all of her 14-count indictment, Plunkett was dismissed by the district judge Michael Villani. However, she was shockingly arrested again for charges of bribing or intimidating a witness, which is a felony. According to her lawyer, her guilty plea comes after reaching an agreement with prosecutors. The agreement is a good resolution for all sides involved. It's the choice that she made that's best for her, and I respect that. Ultimately, it came down to being tired of continued litigation. Fighting a war on two fronts takes a toll on you, and remaining in custody pending your trial and resolution of your other case is really hard to do. She pleaded guilty of possession of a telecommunication device and was ordered to serve 3 years of probation and was later disbarred. In the next case, Christopher Reynolds, a 44-year-old Florida attorney, shocked everyone. He was accused of stealing nearly $800,000 from his clients. He was arrested by the Pinellas County Sheriff's Office for multiple charges, including money laundering and grand theft. He started his private practice in Seminole back in 2015, representing victims of vehicle crashes. He had dealt with at least 16 clients before they had their money stolen by Reynolds. It was back in October that the detectives came to know about the theft when one of Reynolds' clients came forward. The client complained to the authorities that her lawsuit for $100,000 had been settled months earlier. However, Reynolds never notified her about this. The investigators made a shocking discovery. Reynolds had forged his client's signature on the legal documents and collected the money from insurance companies that should have been disturbed to pay medical bills and provide other compensation related to car accidents. This was a similar pattern for most of the clients that had availed his services. Once he had settled his case, he would disappear without a trace, never to be seen again. He would neither pick up the calls or respond to the voicemails, and would cut off all forms of communication he had with the client's eye. In another incident, the lawyer pocketed the woman's $100,000 and continuously lied to her in the communications before it abruptly stopped that he was going to solve this with the insurance company. He also forged the woman's name on settlement documents, and he never paid her medical bills with the settlement money. His highest theft amounted to $148,750 from a client back in 2019. Sheriff Gualtieri claimed that the clients must have had serious injuries for their settlement money to be in 6 figures. Now, what did he do with the money he stole? The answer will shock you. The lawyer had a drug abuse problem. He used a portion of the stolen money to purchase drugs and nearly spent $30,000 on pornography and $424,000 on prostitution. Sheriff Gualtieri later commented, "They're licensed to practice law. They've got the boxes checked. They've got the credentials. They've got the credibility that goes with that, and they're really just a thief who is ripping them off." These are not isolated cases. Many lawyers who are corrupted and have been cheating people for years are roaming free in this world with no one to put a check on them. What do you think of these lawyers? Were they punished approximately? Let us know your thoughts in the comments below. Don't forget to press the bell icon and subscribe to our channel for future updates.
Ahmed Al-Manhali, a United Arab Emirates citizen, traveled to Avon, Ohio in June 2016 for medical treatment at the Cleveland Clinic. Upon arrival at the Fairland Inn and Suites, he was informed that the hotel was fully booked due to the Republican National Convention. Ahmed politely requested alternative accommodation options. While waiting in the lobby, a SWAT-style response occurred, with Avon officers arriving and detaining Ahmed, who was simply walking out of the hotel while on his phone.
On the ground now! Get on the ground! Get on the ground! Down! On the ground! Do it now! Get on your car. Down!
Confused by the situation, Ahmed questioned the officers, but they handcuffed and searched him, damaging his phone in the process. They found a second phone, which Ahmed used for business purposes.
Take the phone away! Cover the entrance, help me get back.
What is it?
Go down there.
What happened?
Despite no evidence of wrongdoing, the officers treated Ahmed as a terrorist, disregarding any investigation or backstory. Simultaneously, an officer spoke to the hotel receptionist who had made a 911 call, falsely claiming Ahmed had pledged allegiance to ISIS. The officer soon realized it was a false alarm and called off the search. Meanwhile, Ahmed collapsed and passed out, prompting paramedics to administer aid and to take him to a nearby hospital. The incident gained international attention, leading to the United Arab Emirates Ministry of Foreign Affairs to demand an apology from Avon officials. The mayor and police chief apologized to Ahmed, emphasizing that the incident did not reflect their community's values. Marriott International, the hotel's owner, expressed regret and committed to training to prevent similar occurrences.
You should not have been put in that situation like you were.
There were some false accusations made against you, and those are regrettable.
Mayor
Jensen said in a statement, "This was a very unfortunate incident and does not reflect our community. Avon is proud to welcome visitors from the United Arab Emirates and other countries who regularly come to Northern Ohio for tourism, business, medical care, or education."
The settlement aimed to compensate Ahmed for physical, psychological, and financial damages. However, he still faced lasting emotional distress, was haunted by the officer's eyes, and experienced sleep disturbances. The incident highlighted the need for improved cultural understanding and sensitivity among law enforcement personnel. Here we have Brian Filipiak, a 47-year-old Washtenaw County Sheriff's Lieutenant, who was off duty when he got pulled over. Deputy Morrison, after stopping Lieutenant Filipiak, informed him about the reason for the traffic stop. Subsequently, Deputy Morrison inquired if Lieutenant Filipiak had consumed any alcoholic beverages that afternoon. In response, Lieutenant Filipiak acknowledged that he had indeed consumed a couple drinks. After Deputy Morrison confirmed Lieutenant Filipiak's identity, he returned to his vehicle and instructed the lieutenant to exit the truck for a field sobriety test. The purpose of the test was to assess whether Lieutenant Filipiak had consumed an excessive amount of alcohol, despite it being evident he was clearly unfit to drive. Exhibiting evident signs of severe intoxication, such as slurred speech and watery eyes, Lieutenant Filipiak left no room for doubt that he was heavily under the influence.
Okay, you got your ID?
However, despite this clear indication, Lieutenant Filipiak adamantly refused to comply with Deputy Morrison's request to step out of the vehicle. Instead, he insisted that Deputy Morrison should either allow him to return home or let him sleep it off on the side of the road. In response, Deputy Morrison firmly informed Lieutenant Filipiak that his options were limited and made it clear that he would not allow him to be released in his current condition.
Multiple reckless driving calls about you. Okay? And then when I'm calling you, you're hitting the shoulder of the road. You been drinking? How many?
Just a couple.
Okay. What are you reaching in the back for?
Huh?
I seen you reaching in the back. You have an open container back there? Okay, you been drinking on the way here?
Um,
Got your registration, proof of insurance? Do you have a firearm on you? Okay.
fuck.
Do you got your pistol? Are you a corrections officer or just deputy? Lieutenant? Okay.
Despite Deputy Morrison's persistent attempts to persuade Lieutenant Filipiak to exit the vehicle, the latter remained adamant in his repeated request to be released. He proceeded to assert that Deputy Morrison's job would not be jeopardized if he let the situation slide, emphasizing the potential consequences for himself if the matter were pursued.
Brian, I'm going to have you step out of the car. I'm going to do a field sobriety test for you. Okay?
However, Deputy Morrison understood that ignoring the incident would not only lead to his termination, but also result in misdemeanor charges carrying a penalty of up to 1 year of imprisonment or a fine of $1,000. Deputy Morrison was fully aware of the extent of Lieutenant Filipiak's intoxication, as he had allegedly observed the lieutenant discarding open containers in the back seat during the traffic stop.
I'm going to ask you to step out of the vehicle. What would you like me to do?
Just let me.
I can't. I had multiple phone calls. You'd be in the same situation if I was in the vehicle in your county, correct?
All right, just let me stay here.
You can't. I'm going to ask you nicely to step out of this vehicle. Brian, my hands are tied. If I let you go, I'm going to lose my career over you. You don't think I wouldn't?
No.
This is northern Michigan. We're a small department. Okay, I'm going to ask you nicely to step out of the vehicle. You know I have my job to do. You know that.
Yeah, and I just want you.
And I understand you're Your point, your position. Okay, I'm trying to be as cooperative and nice to you as I can.
Despite Deputy Morrison's continuous efforts in trying to have Lieutenant Filipiak step out of the vehicle,
after nearly 5 minutes of persistent requests for Lieutenant Filipiak to exit the vehicle,
just let me go.
I can't let you go. We're way past that point. You know this. You're a lieutenant. You know how this works.
Yeah, I do.
You would tell one of your deputies if they called you right on the side of the road. And they ask you what to do. So, if one of your deputies is in the position as I am right now, calling you as a lieutenant, Lieutenant, this is what I got. What should I do? You're just going to say let him go? Why? Just because. You're intoxicated. I know it. You have open alcohol vehicle that you passed back. I know it. You know it. You're a good guy. Ryan, out of this vehicle. I'm asking you nicely. I don't want to see anything worse happen. Okay?
No.
Deputy Morrison, having reached the limits of his patience, opened the door and firmly instructed the lieutenant to step out, avoiding any need for further escalation. Deputy Morrison proceeded to inform Lieutenant Filipiak that he would be arrested for refusal to comply if he persisted in refusing to exit the vehicle. RNO, an abbreviation for resisting and obstructing a police officer, is a felony offense that carries a penalty of up to 2 years of imprisonment, a fine of $2,000, or both. After an additional 5 minutes had passed, Deputy Morrison cautioned Lieutenant Filipiak that he would be tased if he continued to resist compliance with his instructions. Consequently, Deputy Morrison retrieved his taser and aimed it at the lieutenant, while firmly warning him that failure to comply would result in being tased. Deputy Morrison even considered using the backup taser at that moment. In this situation, Deputy Morrison possessed the authority to employ his taser and would not have faced repercussions for doing so. Fortunately, the threat of being tased successfully persuaded Lieutenant Filipiak to finally exit the vehicle. As anticipated, Deputy Morrison did not tolerate Lieutenant Filipiak's resistance, instructed Lieutenant Filipiak to occupy the back seat of his patrol car, intending to transport him to the police station. Despite Deputy Morrison's clear directive to sit in the car, Lieutenant Filipiak persisted in his refusal, stating, "I am who you guys are. Do you guys realize that?" This remark strongly indicated that Lieutenant Filipiak was attempting to exploit his position of authority, seeking a preferential treatment based on his status.
All right, we're done with this.
Hold on.
Talk to me. Yes or no? Are you doing field sobriety tests?
All right, so if this was the other situation...
Lieutenant Filipiak clearly held the belief that he was exempt from abiding by the law. However, the officers present at the scene were determined to make it evident that such was not the case. Following some further struggle, they managed to successfully place Lieutenant Filipiak inside the patrol car.
I'm not resisting, but let's stop.
Let's
talk about it. Okay.
We've talked. I don't want to put you on the ground.
No,
I don't want to make this worse.
All right, I will just sleep it off.
Dude, stop it right now. You know? Stop it.
Allowing for his transportation to the police station where he would face the consequences of his actions. Subsequent breath tests conducted at the police station revealed that Filipiak's blood alcohol level registered at 0.28 and 0.27%. For context, the legal limit for operating a motor vehicle in the United States is a mere 0.08%.
What happens? We're going to take you to the jail and ask for a data master. And if you refuse that, we're going to get a search warrant for your blood. Brian, have a seat.
Stop, guys. Hold on.
Therefore, Lieutenant Filipiak's blood alcohol concentration was over 3 times the legal limit, subjecting him to Michigan State's super drunk law, which carries penalties of up to 180 days in jail, fines of up to $700, and up to 360 hours of community service. So it's time to watch our next case. On July 26, 2021, the Orangeburg Department of Public Safety received a distress call from a female resident of Colton Village Townhomes in Orangeburg, South Carolina. The caller reported that a man was vigorously banging on her door and window, attempting to gain entry. Furthermore, she alleged that the man possessed a firearm tucked into the waistband of his jean shorts. In response, dispatch promptly directed all officers in the vicinity to respond without delay. Officer David Lance Dukes arrived as the first responder at the scene. With his firearm drawn, Officer Dukes exited his patrol car and proceeded to instruct a 58-year-old disabled man, along with his cousin DeMario Julian, to immediately lie on the ground. At this juncture, it was evident from the body camera footage that Mr. Gillard was complying with Officer Duke's commands. The recording captured Mr. Gillard raising his hands in the air and proceeding to lower himself onto his hands and knees as directed by the officer. However, before Mr. Gillard could fully assume the prone position on the ground, Officer Dukes unexpectedly and forcefully stomped on Mr. Gillard's neck. The impact caused Mr. Gillard's head to forcefully strike the pavement, resulting in a bruised forehead. Subsequent investigations revealed that Mr. Gillard's delay in complying was due to the presence of metal rods and pins in his leg and hip as a result of a previous injury. Following the aggressive act, Officer Dukes promptly restrained Mr. Gillard by placing him in handcuffs. Immediately afterward, Officer Dukes informed a second officer at the scene that there should be a gun behind Mr. Gillard, suggesting that Mr. Gillard had allegedly left a firearm behind the white SUV where he had been positioned prior to the confrontation.
There's a gun behind me. There's a gun, I believe, behind me. I ain't got no gun there.
Mr. Gillard assured Officer Dukes that there was no gun present, and upon a quick examination, the second officer confirmed the absence of any firearm. Officer Dukes proceeded to conduct a search of Mr. Gillard's person, accusing him of failing to comply with orders. However, as evident in the earlier body camera footage, Mr. Gillard had been complying with Officer Dukes' commands from the beginning. Not once did Mr. Gillard exhibit any behavior that could be perceived as a threat, thereby negating Officer Dukes' justification for excusing excessive force against him. Once Officer Dukes ensured that Mr. Gillard did not possess a firearm, he decided to search the vicinity of the SUV himself in hopes of locating the alleged weapon. It swiftly became apparent that there was no gun to be found. Instead, it was discovered that Mr. Gillard had been carrying a stick wrapped in shiny silver tape, which he typically used as protection against aggressive stray dogs. Officer Dukes and the second officer helped Mr. Gillard back up onto his feet, at which point he began expressing his dissatisfaction regarding the unnecessary impact of his head on the concrete. The visible injury to Mr. Gillard's forehead, marked by a bruise and swelling, further supported his claim. In response to Mr. Gillard's confrontation regarding the incident, Officer Dukes provided a reply. At this point, it became apparent that Mr. Gillard was in need of medical attention. However, neither of the officers present on the scene initially took this into consideration. Fortunately, Officer Queenie Polidor arrived and promptly recognized the necessity for emergency medical services, requesting EMS assistance. As Mr. Gillard continued to express his grievances regarding the incident, Officer Dukes approached Officer Polidor and another responding officer to inform them about the situation. However, Officer Dukes' account was far from truthful. He claimed that when Mr. Gillard walked in front of the SUV, he believed Mr. Gillard was carrying a gun and repeatedly instructed him to drop it. Officer Dukes made further allegations claiming Mr. Gillard had his hands in his pockets and repeatedly ignored requests to show his hands. However, the body camera footage once again contradicted Officer Dukes' statements.
He was in front of the car when I came up, and he was walking like this. And I thought it was a gun at first. I said, drop the gun, drop the gun, drop the gun, drop the gun. I had him at gunpoint.
Clearly showing Mr. Gillard complying with the orders by keeping his hands raised above his head. Officer Dukes mentioned to a fellow officer that he wanted to take the stick as evidence, stating that it was the reason for his actions. In response, the fellow officer promptly questioned the necessity of using the stick as evidence, pointing out that the body camera footage would suffice. EMS arrived at the scene to attend to Mr. Gillard's condition. While Mr. Gillard was being examined, Mr. Julian approached Officer Dukes and requested a card with his details on it. In response, Officer Dukes promptly informed Mr. Julian that he did not possess a card and clarified that the department did not issue such cards in any case. Officer Polidor quickly recognized Officer Dukes' misstatement and promptly corrected him. She asserted that they indeed possessed cards and proceeded to provide Mr. Julian with her own cards as requested. On July 31, 2022, the South Carolina Law Enforcement Division announced that Officer Dukes was taken into custody and charged with first-degree assault and battery. Several months later, in November 2021, Mr. Gillard received a compensation settlement of $650,000 from Orangeburg, South Carolina. City officials additionally expressed their commitment to establishing a citizens task force to provide oversight and guidance regarding interactions between residents and the Orangeburg police.